Good morning, friends and colleagues. I'd like to begin with a thank you and an apology. I'd like to thank Connectus for convening this important event and for inviting me to take part. And I want to apologize for not being able to be there with you, despite my intention to do so. I do look forward very much to learning of the results of your discussions and of working with you thereafter. In the short time that I have, I wish to focus on the question of implementation of the views of the United Nations treaty bodies in individual cases, or in the lexicon communications. And I'm basing this presentation on research that we have conducted and which is continuing. Public interest litigation is generally aimed at securing concrete remedies for individual complainants, as well as more general reforms of policy and institutional practice. Such changes are not easily won, even in the most developed domestic systems. So pursuing such litigation in international and regional human rights fora may strike some as fanciful. After all, these systems are relatively new. They have fewer resources, and they rest on less settled juridical foundations than their domestic counterparts. And yet the number of cases filed with and judgments delivered by such bodies steadily increases. To what end? What is the record of implementation of these decisions? What procedures exist to monitor and promote implementation, and how can they be improved? These questions prompted the Open Society Justice Initiative to embark on an extensive study of judicial decisions in the three major human rights systems in Africa, the Americas, and Europe, and in the United Nations treaty body system. The Justice Initiative engages in litigation around the world, representing applicants, intervening as a third party, or providing assistance to national counsel where that's appropriate. We have a specific interest in learning how to make our litigation more effective, including through full and expeditious implementation of court judgments. And as advocates promoting the rule of law, we have a more general interest in fostering well-functioning regional and international courts as essential elements of a global open society. The implementation of its judgments is the central measure of a court's efficacy. Without it, the situation of those who should be helped by the court's ruling does not improve. Even the best and most profound jurisprudence may be deemed ineffective if not implemented, and the very legitimacy of the court called into question. An implementation crisis currently afflicts the regional and international legal bodies charged with protecting human rights. The goal of our research is to help address the crisis by exploring implementation, the conditions under which states implement the decisions of the various rights systems, the extent to which procedures to monitor implementation exist, and how they can be improved. 5 United Nations treaty bodies can currently receive individual communications: the Human Rights Committee, the Committee Against Torture, the Committee on the Elimination of Racial Discrimination, the Committee on the Elimination of Discrimination Against Women, and the Committee on the Rights of Persons with Disabilities. Because the Human Rights Committee has adjudicated the greatest number of communications so far, we have examined its practice in greater detail. In 1990, the Human Rights Committee became the first treaty body to create the position of Special Rapporteur for Follow-up on Views, with a 2-year renewable mandate to monitor a state's implementation of the decisions or views of the committee. Once the committee's decisions are published, states are expected to reply within 6 months, explaining how they intend to implement the committee's proposed remedial scheme. However, many states do not reply, and those that do often simply contest the factual basis of the committee's decision or challenge its interpretation of the International Covenant on Civil and Political Rights. When a state's reply is received, it's transmitted to the members of the committee who authored the decision and to the victim or his or her representative, who may respond to the state's submission. A summary of the state's response and the committee's comments are subsequently published in the committee's annual report to the UN General Assembly. As of 2009, the committee has started issuing periodic progress reports on follow-up to certain individual communications. Where the state's reply is deemed inadequate, the committee will typically state in the report that it regards the dialogue as ongoing. Thereafter, the Special Rapporteur may conduct follow-up consultations with diplomatic representatives to facilitate implementation. However, because the Special Rapporteur has no independent budget, such consultations are effectively limited to the 3 sessions during the year when the committee is in session. According to data compiled by the Petitions section within the Office of the High Commission for Human Rights, which is the division that provides administrative support to the treaty bodies, compliance with the decisions of the treaty bodies is generally quite poor. Based on its own data, of the more than 500 cases in which the Human Rights Committee found violations of the ICCPR, fewer than 15% have received what the committee considered to be a satisfactory response. Of the remaining cases, the state's response was either unsatisfactory in that it failed to address the merits of the committee's findings, or the state simply did not respond at all. Implementation of Human Rights Committee decisions appears to have actually deteriorated over time. Although compliance at present hovers around 12 to 15%, the committee's 1999 report to the General Assembly noted that roughly 30% of the replies received could be considered satisfactory. In a 2001 report on the Human Rights Treaty Body system, Ann Bajewski observed that remedies were forthcoming by states parties in only 21% of cases. This downward trend is to some extent explained by the fact that the committee's individual communications workload has increased in absolute terms during that time. I should note that the situation is less grim for the Committee Against Torture, which has a nearly 50% rate of compliance and is the only other treaty body to have adjudicated a comparatively large number of communications. CEDAW, the Women's Committee, has registered fewer than 30 communications to date, although it has had a few successes with implementation. The CERD has heard even fewer cases. One enduring challenge to the implementation of UN treaty body decisions is that they are not legally binding. Nonetheless, a number of commentators have argued that states, having accepted the jurisdiction of the communications procedure, remain duty-bound to respect their treaty obligations. Moreover, compliance with the committee need not be tethered to the fact that a state considers itself legally bound to implementation. In a number of cases, for instance, states that have expressed disagreement with the committee or been negligent in follow-up procedures nevertheless compensated claimants on an ex gratia basis or issued a financial remedy which, while not correcting the policy which may have given rise to the violation, offered some measure of compensation to the individual grievant. Generally, successful implementation has occurred in cases with high political visibility and cases brought against states with a sophisticated rule of law tradition. Where implementation has taken place, it is frequently due to a strong civil society presence capable of complementing the committee's follow-up efforts and applying other domestic pressures. Even where states have not strictly complied with the committee's views, there are examples of successful dialogue between the state party and the committee, suggesting that the treaty body system serves an important persuasive function that can build momentum for larger reforms. Despite these qualified successes, the failures of implementation are many. While the Special Rapporteur can play an important role in pressuring states, it is clear that the Office of the High Commissioner for Human Rights has inadequate time and resources to monitor the entire follow-up docket. Reform of the treaty monitoring bodies has been a topic of debate for many years. Later this week in Dublin, a number of actors will meet to search for consensus on a series of recommendations that the High Commissioner may consider. Many issues are involved, and to be sure they will continue to be discussed for some time. But there are a number of steps that can be taken by respective parties to the process, specifically to improve implementation of the treaty body's decisions. Let me first offer recommendations for the United Nations system, then the users of the system, or those who bring communications, and finally for states. For the UN system, first of all, of course, greater resources are needed to support the follow-up rapporteur. The current resource commitment is insufficient to the scale of implementation monitoring that's required. In this regard, it may be advisable to consider the appointment of several follow-up rapporteurs who could each handle a smaller portfolio of cases, perhaps on a country or theme-specific basis. The CEDAW committee has followed this approach with some success. Intersessional follow-up meetings and follow-up missions in countries that have particularly poor records of implementation should be a priority. The committee has conducted only one country visit to date, and it was over 15 years ago, and this is the Human Rights Committee to which I'm referring. Such consultations could be undertaken either by the follow-up rapporteur or other committee members, perhaps in conjunction with UN country teams. Second, it is essential to improve the visibility, accessibility, and accuracy of information that's pertinent to implementation. Statistical data presented in the Human Rights Committee's annual report needs updating and revising, including more accurate classification of the character of state replies and clearer criteria for what constitutes satisfactory implementation. For example, the committee recently decided to close the follow-up procedure for the case of Williams versus Spain, which concerned racial profiling, a case which the Justice Initiative helped to litigate. The closing happened despite manifest deficiencies in the state's response, which were outlined in letters to the committee. Those letters received no substantive reply, and thus it was with some surprise that we learned only by reading a newsletter published by OHCHR's Treaty Division that the case was closed and was considered an example of successful implementation. There have been some creative efforts to present data on implementation more systematically within the UN system. During his tenure as Special Rapporteur on extrajudicial, summary, or arbitrary executions, Philip Alston devised a scheme which included all communications we received in the year against various states. It highlighted the specific rights violations that were alleged, something the treaty body database does not do, the number and category of individuals concerned, whether or not and how many responses were received by the government in question, and the character of those replies. And of the latter, Alston created the following 5-point typology: no response, receipt acknowledged, allegations rejected but without adequate substantiation, cooperative but incomplete response, and largely satisfactory response. A similar typology could be devised to assist state implementation of treaty body views. Third, the inclusion of data as to whether states have complied with interim measures ordered by the committee, such as moratoriums imposed on the carrying out of capital sentences, would be useful, as would a digest of the treaty body's remedies jurisprudence. Fourth, the treaty body should endeavor to provide more thorough and comprehensive reasoning in their decisions, which would help provide a sounder intellectual foundation for any follow-up measures. Relatedly, more attention must be given to what is specifically requested of states where a violation is found. The more specific and practical guidance the treaty bodies can give, the better. By way of illustration, several cases that had been decided against Colombia were never implemented because, according to the Colombian Ministerial Committee, which is the body established to ensure the implementation of Human Rights Committee and Inter-American Court decisions, the absence of a specific remedy in the views led it to recommend that compensation not be paid to the victims in question. In the Williams case on racial profiling, the committee stated that in addition to a public apology, Spain must take all necessary steps to ensure that its officials do not repeat the kinds of acts observed in this case, but it did not further elaborate. Finally, there needs to be a more sustained, mainstreamed approach to follow-up throughout the UN protection system. The High Commissioner for Human Rights should continue to raise the non-implementation of treaty body views in her meetings with state representatives. In the context of the Universal Periodic Review, OHCHR should more systematically provide implementation about implementation of treaty body views as part of its compilation reports. While the office has included information about the implementation of concluding observations and special procedure recommendations, it has only recently begun to do so for treaty body views. If consistently provided within the context of the UPR process, this kind of information can serve as the basis for questions posed to the state under review and for recommendations by the Human Rights Council. More generally, greater consideration should be given to collaboration between the UN's treaty-based and charter-based bodies. Presently, treaty body observations and views barely figure on the UN Human Rights Council's agenda. Legitimate concerns have been raised as to the risks of treaty body engagement with the Council. At the same time, the Council is a political body capable of exerting pressure on states, and in certain cases, it may be a useful tool to press for implementation. In this respect, the Council might serve a function not unlike the Council of Europe's Committee of Ministers, the political body which is charged with monitoring the execution of judgments of the European Court of Human Rights. Finally, there should be more systematic coordination between the treaty bodies and the UN Special Procedures mandate holders, so that they may address, where appropriate, the issue of implementation in the course of their duties. Other UN specialized agencies, including UN country teams, might also be in a position to raise implementation of treaty body decisions in the course of their duties. So these are a number of recommendations that speak to the UN system. But representatives of petitioners and associated NGOs can also contribute to implementation. First, by being more strategic and thoughtful in considering which treaty body is the best forum, and even whether other UN mechanisms, such as the UN Special Procedures, might in a particular instance be more effective. Second, by crafting with care requested remedies for the treaty bodies to consider asking of states. And third, by giving more priority to follow up at the domestic level after a decision is issued, including by citing to treaty body decisions in advocacy before domestic courts and other institutions. Finally, states can make implementation more possible by creating an institutional locus of responsibility for monitoring compliance with individual decisions and ensuring that adequate measures are taken by the appropriate agencies of government. The decisions of treaty bodies often require action by the executive, the legislative, and/or the judicial branches. Ensuring formalized channels of communication among these branches in matters relating to implementation is essential if implementation is to improve. Discussion about these communications challenges may present a more productive way to unpack the elusive concept of political will in a manner that leads to action. And while the precise nature of institutional form may vary, a number of positive examples already exist. The United Kingdom's Joint Committee on Human Rights is a rare example of a special parliamentary body with a specific mandate to verify and monitor the compatibility of a country's law and practice with the jurisprudence of regional and international human rights mechanisms. Only 5 other national parliaments within the Council of Europe currently have a similar body. Peru's implementation law establishes a process by which the Foreign Ministry communicates the decisions of regional and international bodies to the Supreme Court, which is then responsible for transmitting the decisions to the courts that have jurisdiction over the matters at issue. A different model exists in Colombia, where an implementation law provides a process for the consideration and payment of orders of compensation issued by the Human Rights Committee and other bodies. As noted, however, this model has failed treaty body plaintiffs in cases where the Human Rights Committee did not recommend a specific remedy. Finally, in a number of countries, national human rights institutions and ombudspersons play a constructive role in ensuring implementation of international decisions. In conclusion, there is a great deal that can be done within existing budget constraints, even though more resources are surely needed if the human rights litigation system within the United Nations is to gain the respect and influence which the victims of those violations need. I want to thank you very much for your attention and look forward to learning of the results of your discussions.